Hola, hola, hello. I am a dual licensed attorney practicing in both the United States and Brazil. If you are a parent in Latin America right now whose child was taken to the US for a temporary trip and never returned, your next legal steps are the most critical decisions you will ever make. You agreed to a short family visit to New York. You packed their bags and waited for the day they would fly back. Then comes the text message or the blocked number, and the terrifying realization: your child is not on that return flight. Under international law, this is wrongful retention. A trip that begins legally on a standard B2 tourist visa becomes an act of international child abduction the moment the agreed-upon return date passes and the parent in the US refuses to send the child back. Urgent. Many parents in this position immediately hire a local family lawyer in the US state where the child is being kept, hoping to fight for custody in a local courthouse. But look at this building. This is the New York County Family Court. For an international abduction case, this is often the wrong place to start. Local state family courts are designed for domestic disputes, not international treaties. State courts prioritize an evaluation of the parents to determine who provides a better home. This process is notoriously slow, often taking months or years to reach a final decision, time that the parent in the US uses to integrate the child into a new environment. When you engage in a state-level custody fight, you effectively ask the court to oversee a permanent life in the US. By the time a state judge finishes their review, the calendar has often passed the 1-year mark, allowing the other parent to argue the child is now settled in America. This delay creates a legal reality where returning to your home country becomes nearly impossible. To avoid the delays of the state system, we use a specific federal mechanism, the Hague Convention on the Civil Aspects of International Child Abduction. In a Hague Convention case, the U.S. federal judge is not there to decide custody. In fact, the treaty prohibits them from weighing in on which parent is better or where the child should live long-term. In the United States courthouse, the focus is strictly on jurisdiction. The court's only job is to determine the child's habitual residence and decide if they were removed or retained in violation of that country's laws. Habitual residence is a factual test. We must show the court that the child's actual life, their home, their school, and their social circle, was in Brazil for at least 6 months before the retention began. Once habitual residence is proven, the Hague Convention generally mandates the child's immediate return. While there are specific legal exceptions, such as proving a grave risk of physical or psychological harm, the burden of proof for these defenses is extremely high. The default under federal law is that the case belongs back in Brazil. Shifting the case to federal court removes the incentive for the other parent to stall. It strips away the local custody arguments and focuses the legal fight on the only question that matters: which country has the right to hear the case? Winning a Hague case in the U.S. requires a structured approach to evidence that satisfies federal standards. First, we establish habitual residence by documenting the child's daily life in Brazil. We compile school enrollment records, pediatric history, and government documents into a single, verified file that proves the child's center of life was never the United States. Second, we must prove that you never consented to a permanent move. We use the abducting parent's own records to demonstrate the original intent of the trip. We present the round-trip flight confirmation, the specific expiration dates on their tourist visas, and certified translations of messages where the other parent explicitly acknowledged the trip was only a vacation. Finally, we must act before the 1-year mark. If a petition is filed after 12 months, the court has the discretion to allow the child to stay if they are well settled in their new environment. Acting quickly is the only way to prevent this defense from ever being raised. Success in these cases relies on documented facts, not emotional appeals. It requires a precise filing in federal court before the legal timeline creates a disadvantage you cannot overcome. Most local U.S. lawyers do not have experience with Brazilian law or international treaties. You need a specialist who understands both the Brazilian legal culture where your evidence originates and the U.S. federal rules where the case will be decided. As a dual-licensed, trilingual attorney, I handle the authentication of Brazilian documents and ensure the cultural context of your communication is accurately conveyed to a U.S. federal judge. The longer you wait, the more difficult it becomes to invoke the mandatory return provisions of the Hague Convention. Every day that passes helps the abductor's case. The evidence of your child's true home is already there. You need to ensure it is presented in the correct court before the one-year window closes. If your child is being wrongfully retained in the United States, do not wait for a state court to take action. Look at the description below this video to book a legal consultation with me right now. We need to start this process today.